Hello again. Welcome to this series of podcasts about the difficult and sensitive issue of domestic and family violence. Many thanks to Donna Cooper for her use of her materials. In this first podcast, I will discuss with you some of the social context and recent inquiries and evidence about family violence, and provide and discuss some of the research on types of violent behaviour. First, though, we begin with examining some of the sources of best practice in domestic and family violence matters. On 27 July 2016, the Queensland Law Society released its Domestic and Family Violence Best Practice Guidelines. Those guidelines are available on the Blackboard learning page for this module. They do not, of course, operate as legal principles, but they represent the most up-to-date procedural approach. In this course, we are going to do our best to incorporate relevant parts of those guidelines into your teaching. There are a few key principles drawn from the Queensland Law Society Best Practice Guidelines that can help the way we discuss family and domestic violence. First, family violence can affect anyone, regardless of age, gender or wealth, where they live, or their cultural background. Second, when discussing issues of family and domestic violence, listen and respond respectfully and sensitively. Third, develop and maintain your own knowledge of the social context of domestic and family violence, including power, control, and gender. Fourth, make sure that you know and keep yourself updated on the law so that you can give considered advice. Fifth, and finally, consider cultural, religious, and gender issues which may have an influence on a client's reluctance to disclose and discuss family and domestic violence. There are other resources available to assist in developing best practice. The Family Court of Australia's Family Violence Best Practice Principles is available on the Blackboard page. This document provides both a practical framework for representing clients in litigation, but also discusses some of the legal principles, including the concept of unacceptable risk, which we will return to later. I've also provided a link with the slides to the Family Law Council Family Law section of the Law Council of Australia, Best Practice Guidelines for Lawyers Doing Family Law Work. I should pause at this point just to examine some terminology. There are some specific legislative terms that we will look at shortly, in particular the concept of domestic violence in state legislation and the definition of family violence in the Family Law Act. The term domestic and family violence is not a legal technical term of itself, rather it is just an umbrella term covering the whole of the area. Now it's time to consider some of the recent reports and evidence about the social context of domestic and family violence. We begin with a report by the Domestic Violence Task Force, chaired by Dame Quinton Bryce, delivered to the Queensland Government. This report is called Not Now, Not Ever, Putting an End to Domestic and Family Violence in Queensland. The report is very long. The first volume runs to 368 pages. That volume is on Blackboard in this module. I recommend that you limit your reading just to the executive summary and the recommendations. The task force reported in 2013-14 there were 66,016 occurrences of domestic and family violence reported to Queensland Police. This equates to over 180 incidents of domestic and family violence being reported every day across the state. 17 homicides relating to domestic and family violence occurred in Queensland in 2012-13. On average, across Australia, one woman is killed by her partner every week. The annual cost of domestic and family violence to the Queensland economy is estimated to be between $2.7 billion to $3.2 billion. The picture in Aboriginal and Torres Strait Islander communities is even bleaker. The task force was deeply distressed by what it heard about violence in these vulnerable communities. Violence and abuse is reported as being so prevalent in some communities as to become normalised. The people who live there consider violence to be part of their everyday life. There were 140 recommendations from this report. Some of those were number 66, which recommended that the Queensland Government works with universities to identify suitable ways to incorporate into professional undergraduate courses education and training on how to identify when domestic and family violence is occurring and how to appropriately intervene. Recommendation 97, which provides that the Queensland Government establishes specialist domestic violence courts in legislation with jurisdiction to deal with all related domestic and family violence and criminal proceedings. This is currently being run at the Southport Magistrates Court. Recommendation 118 was the Queensland Government introduce a circumstance of aggravation of domestic and family violence to be applied to all criminal offences. In October 2015, the Australian Institute of Family Studies delivered a report entitled Evaluation of the 2012 Family Violence Amendments. It too is a lengthy report. It is available on Blackboard, but it's there for your additional information only. In that document, the Australian Institute of Family Studies reported that in one study, some 60% of separated parents reported a history of emotional abuse and or physical violence before or during separation, and this continued for a slightly lower proportion after separation, with a longer-term insight suggesting that problematic dynamics continue for some 25% of separated parents up to 5 years after their separation. One of the key messages, and this is perhaps most relevant to legal practitioners, was that parents who do use family law systems tend to be those affected by complex issues, including family violence, mental ill health, substance abuse, and safety concerns for themselves and or their children. There is an article that should be included in the QUT readings for this module called Differentiation Amongst Types of Intimate Partner Violence, Research Update and Implications for Interventions by Kelly and Johnson, published in 2008. As set out on your slide, these authors identify 4 different types of family violence typologies. Of those, perhaps separation-instigated violence and violent resistance, that is, to other violent conduct, are the most recognisable. The term coercive controlling violence is defined as a pattern of emotionally abusive intimidation, coercion and control coupled with physical violence against partners. Situational couple violence is used by those authors to identify the type of partner violence that does not have its basis in the dynamic of power and control. At pages 493 to 494 of that article, the authors discuss the implications for family law disputes. They suggest that, in effect, occurrence of coercive controlling violence is more dangerous for children than other types. The categories used in that article are not universally accepted. For the purposes of this course, though, it is important to recognise that the term domestic and family violence covers a whole range of conduct, but also that the context and frequency of the behaviours may be relevant to determining the level of risk to a child or children in the making of parenting orders. Before turning to the content of the legislation itself, I wanted to briefly deal with the interaction between the legislation. There are 2 acts that we need to look at: the Domestic and Family Violence Protection Act, 2012, Queensland, and of course some provisions of the Family Law Act, 1975, Commonwealth. For the purposes of this course, it is sufficient to be aware that the Family Law Act is fundamentally a civil jurisdiction, which means that police do not have the power to enforce a parenting order. In this course, we do not cover the civil penalty provisions in the Family Law Act for breach of parenting orders and injunctions, nor do we cover contempt of court in parenting cases. Be aware, though, that a family law court does have certain powers to punish those in breach of a parenting order. The only occasion in which police will intervene to enforce a parenting order is when specifically authorised by a court by way of a recovery order, or very limited circumstances where a court has power to issue a warrant of arrest. Otherwise, though, police have no powers in relation to the Family Law Act, and there is no criminal offence of breach of a parenting order. This is why it is particularly important to have specific state legislation for the protection of individuals. There are specific criminal penalties for breach of orders made under the state legislation, and police have extensive powers to arrest and detain offenders, and, in certain circumstances, can apply to a court for orders irrespective of the intentions of the parties concerned. Now, just be sure to take care with the reading of the cases. The Queensland legislation had substantial changes in 2012. Then a further round of changes, came into effect in May 2017. Similarly, the Family Law Act had significant changes that came into effect in 2012. Okay, that's it for this podcast. Thanks for listening. Next, I'll take you through the state legislative framework and examine some of the relevant cases.